All right, and with that, I would like to bring us bring in, virtually speaking, our first panel. I'm going to, all right, thank you guys for turning on your cameras. I'm going to briefly introduce everyone and then turn it over to our esteemed panelists, each of them individually, to discuss the, to introduce themselves. So first, I want to start with Joe DeMarco of DeMarco Law. Joe, do you want to introduce yourself?
Sure. My name is Joseph DeMarco, and I'm a partner at DeMarco Law. We're a boutique law firm of 6 attorneys focused full-time on the law of data privacy and security and cybercrime prevention and response. Prior to starting the firm, I was an assistant United States attorney for the Southern District of New York, where I founded and ran the cybercrime unit there. Spent a lot of our time with clients in the DFS regulated space, as well as their third-party service providers, both providing proactive compliance counsel and then also reactive counsel when an incident occurs. Thanks for having me, Justin.
Thanks, Joe. And next we have Judith Germano of Germano Law.
Thank you, Justin, and thanks so much for including me in this terrific presentation and program. I'm Judy Germano. I'm the founder of Germano Law, which is a boutique cybersecurity and complex fraud law firm. I also am an adjunct professor at NYU School of Law and NYU Stern School of Business, focusing on cybersecurity incident response, risk management, and financial and regulatory risk management. Prior to that, I got to work with Justin and Joe and Luke in the U.S. Attorney's Office, or in the Department of Justice, where I was Chief of Economic Crimes in the District of New Jersey for, I was at the office 11 years, and I'm thrilled to be here today, so thanks.
Thanks, Judy. And next we have Luke Dembowski of Debevoise and Plimpton.
Thank you, Justin. So I'm Luke Dembowski. I co-chair our data strategy and security practice at Debevoise. And like Joe and Judy, prior to that, I was at the Justice Department in many cyber roles over the years, finishing as the Deputy Assistant Attorney General for National Security Cyber, and before that as a Deputy Chief in the Computer Crime Section. So thank you to NYDFS for having me here.
And thank you all for joining us. Very pleased to be able to have such a distinguished panel of experts. That said, I should note here at the outset that all of us, for purposes of this panel, including myself, are speaking only for ourselves and not for our organization. Hoping to get a good cross-section of views here and encourage discussion. And I think just want to remind everyone, though, that we are speaking only for ourselves. So let me start with a question that I'm just going to throw out there for all the panelists, right? I talked earlier about how a lot has changed in the last 5 years in cyber risk, right? And so I'd ask each of our panelists to talk about what they think the most significant changes are in the past few years in cyber risk. And I'll start, we'll go clockwise, at least as everyone appears on my screen. Judy, can we start with you?
Sure, thanks. I would say that one of the most significant changes we've seen in the last 5 years is increased accountability at the board and executive level. And we've also seen increased regulators getting into the mix after DFS's guidance and role, and also increased fines. So higher accountability, higher stakes, and at the same time, obviously, continuing barrage of very both difficult and sophisticated, and then, as you mentioned in your opening comments, Justin, some pretty basic cyber attacks, all of which can cause devastating harm.
Thanks, Judy. Luke?
Just building off what Judy said, Justin, I think we're in an era where on the attacker side, destructive attacks are the flavor of the day. So ransomware has just really been so prolific in recent years, and it's now we face the possible threat of just purely destructive attacks in light of the conflict, the war going on in Ukraine. There's also a trend of systemic supply chain risk. We've seen a number of highly prolific vendors, suppliers for whole sectors and multiple sectors be compromised, and that's led in turn to a scramble for many companies across industry. So that's what I see on the attacker side. On the regulatory side, agree with Judy. The sophistication of regulators is up. The demands are higher. I think it's to be expected, and it's it's up to everyone to step up their game.
And Joe, how about you?
I would agree with all. Yeah, I would agree with all of those, and I'd add a couple more as well. So first is just the slew of governmental entities that are getting into the business of either data security or data privacy. You know, Utah passed its privacy bill just the other day, and I think we'll talk a little bit later about some of the compliance challenges of dealing with just the fact that legislatures everywhere are passing new laws that are imposing obligations on companies that are increasingly going to make companies have to think about how to harmonize all those requirements. That's one thing I've seen increasingly on the legal side. The other thing, too, is along the lines of what Judy said in terms of accountability, not only accountability within the corporation, but increasingly accountability between business counterparties. You know, it used to be in the kind of olden days, by which I mean 5 years ago or 10 years ago, that when an attacker came into company A and then got into company B's networks because B was a permissioned network to network A, and then from B went to C, it used to be in those cases, B, C wouldn't really do much about it other than to kick the attacker out. Increasingly, what I'm seeing are businesses starting to hold each other legally accountable for situations where a hacker comes into their network by virtue of having gained access to another network. And we're starting to see that on the litigation side. We're starting to see it on the arbitration side. And I think that's going to be a staple of commercial litigation in the cyberspace for the years to come.
All great points, right? And let me turn to Luke next. Luke, I know you and all of our panelists have worked with companies that are regulated by DFS, right? And what are the biggest challenges that you've seen for companies in terms of building a cybersecurity program or an InfoSec program that complies with our regulation?
Well, it's been a challenge for many. On the one hand, the regulation has done a great job, as you said, Justin, I think rightfully in your opening remarks, for painting the lines on the court. Like, what are the categories companies need to think about for a holistic cyber program? It's been a challenge to implement things. For example, early on, especially, people worried a great deal about the encryption requirements, about what exactly are compensating controls that would be adequate. They worried about MFA and the extent of the use of MFA required, so forth. I think over time it's become more nuanced or evolved in terms of the challenges. Along with the threat side, third-party risk is very high. And so how do we think about complying with Part 500 now in this world where some of our clients have thousands of vendors? How do you possibly assess everyone from a risk standpoint? How do you impose your terms on a major cloud provider that you really have no bargaining leverage with? And what does that mean from a compliance perspective? So those are some of the examples that have stood out to me in practice over these years.
Okay. And Judy, what about you? Right? What are you seeing as the biggest challenges of building a fully compliant program?
I think one of the biggest challenges that companies struggle with is how much is enough. And because the answer is we really don't know, right? The problems just get bigger, the types of attacks get more significant, and it is a very risk-based analysis. So we do our best to consider all the different factors of what data in the organization is most important to protect, what security protocols are in place for protecting that and other parts of the system, and then also how broad is the risk profile. As Joe mentioned, it's not just the data that you have in your organization, but where else that is going or where else that resides with third parties and others. And so figuring out that scope of information and risk and balancing it with the continuous barrage of threats from people trying to make profit, people trying to steal information, nation states undermining our critical infrastructure, and then figuring out, have we done enough to protect? Do we have the right procedures and protocol and governance in place? And that's where the Part 500 helps in terms of providing a roadmap for companies, but there is still this question of, do we have enough protection? Do we have enough insurance? Do we have ample resources internally and externally? And I'd say that is an important dialogue and a continuing challenge.
No, fair enough. I mean, so our companies have been, right, at least the companies regulated by DFS have been living with the cybersecurity regulation now for 5 years. So Joe, I want to ask you, what are, if any, like the main challenges that exist today, right? Presumably, certainly this is consistent with what I've seen. Some of the early challenges, some of the most challenging things on day one have been to some extent solved in the last 5 years at most organizations. So what's left, or is it all easy peasy now in 2022?
Would that it were. You might not have as many attendees as we do on this call if it were. No, look, I think as everyone on this call knows, right, the DFS statute, it's not a one and done, right? It requires ongoing certification and it requires ongoing analysis of the threats. Now, by definition, that of course means a number of things. First and foremost, it means getting a handle on the fact that, your technology ecosystem is an organic, evolving ecosystem. It is not a static environment. So just right off the bat, right, when you apply a risk-based standard to an ecosystem which every day is changing, new systems are coming on board, systems are going off board, companies are merging, sharing access to databases and networks and file rooms. I mean, all these things make the fact of the need to do an ongoing risk assessment and continually to assess the threats posed to that environment incredibly challenging. So that's kind of, one piece of it that makes it hard to, comply on an ongoing basis. The second piece of it, of course, is that the threats are changing as well. Right? I mean, look, ransomware has been around for at least 20 years. I mean, I worked on ransomware cases 20 years ago, but the nature of ransomware has exploded and morphed in the last 5 years in a very, very significant way. That's going to change, right? In addition to that, right, you're going to have new flavors of or new expressions of threats that were never really quite the problem that they were before. That can include supply chain attacks, right? That's the story of the last 2 years is supply chain attacks. It also includes mass vulnerability. I mean, the Log4j vulnerability had a lot of companies spending a lot of time trying to figure out what the risk of that particular vulnerability was for their organization. And then finally, you have, of course, the new laws and interpretive guidance on existing laws that, that we've mentioned a little bit already. And then finally, the fact of the matter is all of these challenges come together. They are not siloed. And I think a great example of that, right, relates to perhaps, not your guidance per se, but the OFAC guidance of October of 2020 on the ransomware issue, right? I mean, the fact of the matter is, right, if a company is about to consider paying a ransom for a cyber extortion, they need to go through a pretty detailed and sophisticated analysis, which I got to tell you is not that easy, having done it a lot of times with a lot of clients, as to whether or not their payment of that ransom, A, is going to get them where they need to be technically, that's the technical piece of it, but also B, is going to run afoul of interpretive guidance that was issued by the Treasury Department. So I think you've got the technical, the legal, and the threats landscape, all tectonic plates that are moving at the same time, and the need to continually understand and refine risk and remediation in that dynamic environment. Let's just say it's no small task.
Yeah. Okay. Fair enough. I was hoping you would tell us it's all smooth sailing now. Let me come back to you here, right? As cyber has, I think, correctly been perceived more and more as an enterprise risk, and we've seen more oversight at the highest levels, the board and the C-suite. How should companies think about integrating cyber risk into enterprise risk tracking and planning?
That's a great question, Justin. I think one of the classic examples is in their business continuity and disaster recovery planning. If you've planned for a potential system outage, a data center, or a power failure, that's not going to be enough to carry the day in a certain type of cyber attack, like a ransomware attack. The usual BCP recovery times and things are sort of out the window in that context. And so as you think holistically about your risk management program, there are going to be non-malicious types of situations like outages, or a vendor goes down even if it hasn't been your network that's been attacked. And you're planning for single points of failure and redundancy, resiliency. There's another component that comes in when it's a security issue that's been introduced. When systems are infected or potentially infected, you're sort of bringing them back in dribs and drabs. And so that's one example. We've also seen, physical security increasingly be integrated by clients with cyber and technology risk, for example, as to insider threats. We've seen people, be fired as an IT person at a company and then re-enter the facility because their credentials are still good and do something there that creates a whole lot of churn, for the organization going forward. So cyber risks are contextual. They fit into the larger business continuity planning, and they fit into things like physical risk, and integrating them is the challenge. Last thing I'll say is it also has to be part and parcel of your governance structure. So it needs to be holistically briefed up to senior management and the board. And DFS's Part 500 is a classic example of requiring boards and senior management to own these big picture risks. So they need to be briefed on a regular basis. The board and senior management has to make informed decisions. They have to avail themselves of the right expertise if needed to be able to make informed judgments. And so it's a governance thing, it's an implementation thing, but it should be baked into the holistic risk program.
No, I think that makes a lot of sense. I know you alluded earlier to like the insider threat of the disgruntled IT worker. I know all of us are former prosecutors who worked on cyber crimes, right? And there was a period of time when the single most common call was the disgruntled IT or former IT employee case. I don't think those have actually fallen in number. It's just that other threats have become even more common in the last 5 or 6 years. Yeah, that's definitely a big one. So, I wanted to shift the focus or bring the focus a little bit to small and medium-sized businesses, right? I think the financial services industry, like every industry, overwhelmingly consists of small and medium-sized businesses, certainly among DFS licensed entities. And what do you see as the key challenges? Let me throw this to Joe first. Joe, what do you see as kind of the key challenges that are faced by small and medium-sized businesses?
Sure, and let's just first, just level set that a small or medium-sized business in New York is still a pretty big company, right? I mean, you could have a bank with $4 billion in deposits, and you're a small bank, right? But you're not a small bank. You've got $4 billion in deposits, right? Now, maybe you're big enough to have a general counsel, but maybe you're not big enough to have a general counsel, right? If you've got, let's say, $2 billion in deposits. So my point is that, in a sense, right, when you talk about the challenges that small and medium-sized businesses face in complying with the DFS regulations, unless you're talking about like literally a small community bank with one branch or a single title agent in upstate New York, you may very well be talking about a business that's big enough to have kind of all the compliance burdens, but not big enough to have all the compliance resources of, let's say, a privacy program or a privacy department, right? Or a holistic approach. I mean, I completely endorse, what Luke said about, having those kind of programs to do things the right way. I think the challenge for a medium-sized business or even a small business is how to get things as right as possible, given limited funds and given your limited headcount. Now, one of the great things, of course, about the DFS regs, one of the reasons why it's such a success, and I think is being kind of, the subject of, shall we say, inspiration, if not outright, piracy by other regulators, is the fact that it does take account of, different sizes. But even so, right, trying to help a mid-sized bank, let's say, or a mid-sized client through just what it should be doing, and when enough is enough, to echo something that Judy said, is a challenge. Again, I don't think anything that's something can be readily fixed by DFS. I think the statute is kind of good as it is. But I think, maybe perhaps some interpretive guidance on that at some point could be helpful if I can kind of make a pitch for that, Justin, because it is something that does occasion a great deal of internal stress for organizations that are not kind of your largest insurance carrier in New York kind of organizations.
Thanks, Joe. Happy to take the pitch. We'll see. No promises, but actually, a lot of our guidances are inspired by come to our attention because of the asks or the questions that we get from industry. So, no promises, but we definitely take requests. Back to small and medium-sized businesses. Judy, what's your take on that? and what the key challenges are for them.
I agree with Joe in terms of the point of resources, focus, and expertise really being your top challenges. When you're running a smaller, medium-sized business, all the different things that are drawing attention, and you just don't have a team who can necessarily dedicate the same amount of time or money to developing, first-in-class cybersecurity solution. And we've seen for a long time that top level, largest financial services sectors could afford really best across industries for cybersecurity, but just one tier down, and then more so, it just gets harder and harder. And so there, I think, though, in terms of what to do about that challenge, is really focused on what you said in your opening comments, Justin, about how much of the incidents we see are from just a lack of good cybersecurity hygiene. And so even the largest companies are dealing with issues where if they had good multi-factor authentication in place, or made sure they had updates and patches, and those very basic steps for good cybersecurity, I think, can help us tremendously. And even, taking a big company, Morgan Stanley, that paid $120 million in total, 60 million from a lawsuit, 60 million from an OCC fine, because they failed to properly have data wiped from a data center they were no longer using. That's a basic thing of what's your data destruction policies when you're getting rid of old systems, things like that could be easier than some of these more sophisticated attacks to prevent, I think, are really important. But again, that challenge of just making sure that people running a smaller, medium-sized company understand, yes, you have a lot of other things that are pulling you in a lot of directions and limited resources, but this is so critical. It is your reputation, your money, it could be the existence of your business. So it has to be a priority.
Yeah, I mean, I agree with all of that, right? And we do see a lot of those incidents because, like I said, we primarily, just by count, regulate small and medium-sized businesses. And I think that those, I'd say that there are a few advantages to being smaller, right? I think the challenge I've seen in big organizations, and you mentioned the data destruction case, is in a small organization, sometimes the CISO can have a pretty good sense of what the network map is in their head or on a single piece of paper. There are some advantages to that slight reduction in complexity. Although I certainly recognize a lot of the, at a big organization, especially at a multinational, the CISO's job is mostly just trying to implement governance and policies and very far removed from the execution. Not to minimize the challenges that small and medium-sized businesses have, because they certainly have a lot, and we can all see that they are aggressively targeted by cyber criminals. I think because there are so many of them, and because the maturity levels vary so much.
I think it's fair to say it's hard for everyone, right? The biggest companies say, oh, we have multinational operations, we're dealing with global regulations and data all over the world that we can't always have full vision into. And then small companies say, but we're just trying to keep the printer working and machines operating so we can respond to our clients. It's hard everywhere, and that's why, though, it still needs to be prioritized, cybersecurity.
Here. I think when I was preparing, actually, with Judy, I'm going to mention our prep session, and we were going through some of the questions. She pointed out that maybe the audience wants to hear what DFS thinks, right? So I took a stab at that in my introductory remarks. I didn't want to take away airtime from the exceptional panelists that we have here. But let me throw that back to you, right? I talked about what we are thinking about at a high level as we look at revising our reg, right? And maybe we'll go down the road here, and I'll ask each of the panelists, what they would like to see us focus on, or what area they would like they think probably is in the most need of addition or revision. So, Joe, I'll start with you.
Sure. Look, I think the text of the statute is actually very, very good. It really, I wouldn't change much in terms of the text of the statute. I'd really focus on interpretive guidance in a number of areas. One is one I already mentioned, the challenges faced by medium-sized business. Another is, I think, a recognition. It would be good to see some interpretive guidance on what companies are expected to do in those first 72 hours, right? When the fog of war really is as thick as it sometimes can be. And the first 72 hours is a very, very challenging time for a company, other than one that's had a number of cybersecurity incidents, which of course poses its own challenge. But for a lot of my clients, those first 72 hours are the first time they're going through a cybersecurity incident of any kind of heft. And we can, we can talk about what are the things they should do and shouldn't do. But I think, an understanding on the part of DFS as to what, realistically can be expected of organizations that are maybe not the largest organizations in the state or organizations that have not had prior incidents, that would be useful. And then I think the other thing, too, which would be useful, some interpretive guidance on when and under what circumstances reliance upon third-party vendors is appropriate. If I'm not mistaken, and I may be confusing the cases, if I'm not mistaken, in the Morgan Stanley case that Judy mentioned with the improper data destruction deletion, I think actually Morgan Stanley got a certificate of deletion or secure destruction from the vendor that they used in that matter. I'm not sure of that. I don't know if I'm misremembering or not, but the point still bears making, which is, increasingly, obviously, third-party service providers are an important part of any company's cyber security and cyber resilience profile, as well as just their operations. And when and under what circumstances you can actually justifiably rely upon a respectable vendor and their assurances, and when you can't, and when you need to ask questions, I think that would be, again, useful interpretive guidance, at least for some of my clients that I've counseled through these incidents.
Fair enough. Luke, where should we be looking?
So just
This is
building
the part
off
of the panel.
what
This is
Joe
the part of the
said.
panel where I've just gone straight back to soliciting their advice for us. This is advice for us.
Well, I had a chance to canvass our team, which does a ton of work on Part 500 compliance, and also, to Joe's point, response around incidents where the 72-hour reporting rule may come in. And the team, immediately seized on struggles around things like independent agents, small parties, building off what Joe said. I mean, insurance companies with independent producers or agents where, you could argue they're an authorized user, you could argue they're a third-party service provider, but they are small, and it's a real challenge to figure out where they fit and what it means to have them rely in whole or in part on your program as a practical matter. So I think some guidance around that would be good. Here's a harder one, though, which is a lot of people find the certification process to be an all or nothing, like zero-sum type situation. I mean, if you're compliant on the day of certification, but during the prior calendar year, a vendor let you down on retaining something, or MFA, you had to take it down because of a problem with, a vulnerability that wasn't yours. I mean, there's a sort of an all or nothing component and an artificiality to the time. And I understand Sarbanes-Oxley analogies and so forth, but we all know, those of us on here, just how many moving parts and pieces there are in the cyber world. And DFS has acknowledged rightfully that it's such an evolving, fast-moving area. To sign your name to a certification that every single day of the prior calendar year, so some type of guidance around what does it mean, substantial compliance, what does it mean when you're compliant for the first 3 months of the year while you're writing about last year. What does it mean to be able to communicate, which really isn't available now, some areas that you're not so sure about, but that are in progress, since this is evolving. So some nuance and nimbleness around that would be welcome. I understand how complicated that is. I mean, you have many, many covered entities, and if you get a bunch of sort of piecemeal or partial responses, it could be complicated. So I'm not suggesting that it's amnesty day at the ballpark for everyone, but a little bit of nuance there would be welcome.
Okay. And Judy.
I tend to agree well with both my panelists, but I want to just emphasize the points that Joe made in terms of the regs itself are actually incredibly helpful, and more interpretive guidance as opposed to wholesale changes to the regs would be welcome. I'm going to apologize to DFS now, but back when you first introduced the early version of the regs, I had written a piece for Forbes being rather critical that they were too prescriptive and saying, really, we need a more risk-based approach. And kudos to you. I know I wasn't the only one saying that, but I thought that it was those comments and feedback from industry and advisors was taken. And I think what you wound up with is fabulous. And the fact that you keep getting copied, the regs, shows that. One of the guidance, so in terms of areas of interpretive guidance, as Joe mentioned, is quite, and Luke had mentioned earlier, in the biggest challenges is what are we doing about third parties and how far should those risk and responsibilities go? Because Joe, you're right, the Morgan Stanley case where they wound up paying millions and millions of dollars in fines. Arguably, Morgan Stanley would say it wasn't their fault. They had contracted with someone else who was supposed to destroy or wipe the systems clean. And the contract specifically said that Triple Crown could not subcontract that job without written consent of Morgan Stanley, which they didn't get. And they sent it to somewhere else called Anything IT, who did anything with it, but did not do according to the contract. But then that raises all sorts of questions of how responsible do we need to be for data all the way down the line? So when you're collecting it and what you're doing with it, and then when you're destroying it. And I think that's a good example that the risks go longer than we think. And the old PR Newswire and Business Wire cases of sensitive information being hacked while it was protected at the company, but then right before it was released about financial statements and the rest that could change markets, and it was getting hacked at that point of transition, again shows the importance of the life cycle of the information, where it is at all points, how much do we need to preserve, but what's realistic for that. And that's where I think some guidance would be helpful in terms of encouraging a more team-based approach for management. So the bigger entities could perhaps help protect their information when it goes to smaller entities. But to Joe's point, with the B2B litigation that we're seeing, people may be less likely to collaborate as much if then it's shifting liability. So I think that's a really tricky area, and I'm sort of trying to mush a lot into a short point, but supply chain management and third-party risk and vulnerability, it's a big hot mess and it's hard. And so how much are there better protocols, are there technologies that can help to regulate that and ensure that companies are aware of their obligation as to data wherever it is outside of the organization?
Well, all right, thanks. These are all really good points. I want to circle back to a point that Joe raised, right, which is the first 72 hours or the early days of an incident, when there's still a lot of uncertainty, right? To put it, right, to state the obvious, our regulation requires that companies report incidents to us as promptly as possible and in no more than 72 hours. And Joe, how do you think, or how do you think companies should approach? Now, the reality, of course, is that means that that initial report, if it's done timely, is going to come before the company has full information, right? I mean, nobody has full information for 72 hours. And I could say from our vantage point, that is something I like to take the opportunity to let people know that we understand that, right? We require that an incident be reported to us. We absolutely don't require the company be in a position to provide us with full information. It would almost be strange. The company told us that we're done, it's over, we got it locked down in the first 3 days. So we don't hear that, right? But and so I think from our vantage point, that's something that we've had a lot of experience with. And the assumption is that when the first notification comes in, there's going to be a period of time and some follow-ups before we, before the company's in a position to provide us with the best information it has. On the other hand, notification requirements are multiplying. And I don't know that every regulator has that understanding or that approach, right? How would you advise a company to handle reporting in that early period where there's a lot of uncertainty?
Sure. So if the question is how should they handle reporting in that 72-hour period, the one-word answer is carefully. Look, it's a challenge. I think where I see companies get these issues right and wrong is as follows. In those first 72 hours, you have your known knowns, right? You have some data points on what you know happened. You then have your known unknowns, right? And usually you have more known unknowns in the first 72 hours than known knowns. And then you have, of course, your unknown unknowns. Where I see most companies fall down is on that second category, the known unknowns. Either they are not aware as well as they should be about what known unknowns are out there, or they are, but they either discount those known unknowns or minimize them. Look, in the first 72 hours, there are obviously things you do know, and with regard to what you do know, assuming that you have a reportable incident, right, you have to convey those known knowns accurately in a fair, right down the middle of the fairway way, right? You can't minimize, nor should you maximize. You've got to convey what you know accurately and truthfully in kind of like looking for that Goldilocks sweet spot, right? The challenge is really with regard to the unknown unknowns, right? Like when you ask your CISO, well, could it be the case that through this compromise, a backdoor was installed which did implicate, customer information? The answer might be, yeah, that could happen, right? And that is then a known unknown, right? How you handle those known unknowns, first of all, how you rank them in terms of critical importance, how you assess them in terms of how much unknown variable is in that known unknown versus known variable, and then how you package that and convey that to DFS. That's not something really you can teach anyone. That's just kind of like something you get a feel for responding to hundreds and thousands of incidents. And so I would say for the companies that are in that 72-hour time zone where they have any appreciable number of known unknowns, hopefully they either have internal people at the organization who can help guide them through packaging those known unknowns, or they can turn to people outside the organization to help them because they've done that thousands of times. I don't know if that's a helpful answer, and I'm curious to hear my co-panelists' opinion on that question. I actually just would add one last thing on the changes to the text of the regulation. I think it would be helpful if you could exclude holidays and weekends from the 72-hour notification period, because I can't tell you how many weekends that has ruined for me and countless other people. I know it's not going to happen, but again, this is a panel. We can ask anything of you. You can just say no.
That is true. Although it's been my experience that people don't usually take weekends off when there's an incident happening. But like I said, we'll take in all requests today. Luke, how about you? And you can expand your answer if you'd like to beyond just regulatory reporting, but also how to deal generally with the uncertainty that exists in the first few days.
Yeah, no, it's and I will take you up on that to expand it a little bit. So look, you try to control what you can. In other words, if your incident response planning and your training of your first responders, if that's geared to get you the answers right away that you have control over, you're at least well positioned. If you've got template reporting forms, you know exactly what your escalation process is, and you're not trying to create that or figure that out in the moment, you won't lose precious time. So control what you can control. The second thing is, we take the view, with regulators, especially when it's a prudential regulator of yours like the NYSDFS, if you're a covered entity, that the relationship matters, your credibility matters. So are you going to really count down to, hour 71 and, wait till the last possible second? And even though you're pretty sure you're going to be there the next morning, you're not going to at least give a heads up and say, here's what we know so far. This is in an abundance of caution. We don't know if the trigger's met, but we don't want to surprise you. We want to let you know that we're on top of it. And then, when you do have a situation later where you've made a judgment, in another incident, you've said, all right, we don't think we need to report here. You have cred in the tank. I mean, you've shown that you're responsible. You know how to report. You know how to lean forward. We're seeing this, by analogy under GDPR, which is now of a similar vintage. And, people worried about the 72 hours. Now, for most of the data protection authorities, for example, like the ICO in the UK, which has its own GDPR now, if you give them a heads up within the 72 hours that you're not sure, it's a ransomware attack, we don't know for usually for a week or more in a ransomware attack if data was actually taken. You don't know. And you hope that they're not thinking that just because something was encrypted, that all that data is compromised. I mean, hopefully they've moved past that from a technological standpoint. Not everyone in the world has, I will say. And you're able to give them a heads up. And we're seeing them then do what we would hope they would not do, or avoid doing what we don't want them to do, which is propounding 30 compliance questions on you while you're in the heat of the incident. that doesn't help anyone. And so I co-chair the International Bar's Cyber Task Force. And part of what I do is preach to regulators in various parts of the world that there's a time for you to come in and follow up on the compliance or audit things or examine things. It's not in the first 72 hours. Like, you're not helping anybody's privacy or cybersecurity by jumping in with a compliance armada of questions to suck all the air out of the room. And so while the fixers are trying to fix the fire. So we're seeing a maturation on both the regulator side and on the client side in terms of controlling what you can control, lean forward, focus on the relationship, don't split hairs, say what you know and what you don't know, say you'll come back and round it out, if there are material developments.
Yeah.
If I can just add, I think fantastic points by both Joe and Luke. One of the other pieces I just want to mention on this short time frame, it's a crisis, right? Because in addition to what Joe said, the known unknowns and known unknowns, known knowns, and known unknown unknowns. I'm messing it up. Sorry, Joe. But you have to worry about the known knowns that are wrong, right? When people do say, oh, it's just this amount, and it turns out it's something very different. And so internally in the organization, it's really important to have very good communications and a team approach, because sometimes people are panicked. They're worried about who's going to get fired, whose fault is this that it happened. And that disrupts a good flow of information within the organization. So it's not a time to blame. It's just, let's figure this out. Let's work this out. What Luke said about a heads up to the regulators in the time, but then also a respect from the regulators to give some time to sort it all out. But it's a very difficult situation. And that's why having some experience through outside experts helping, or internally by tabletopping these kinds of scenarios, and to understand those first 72 hours, you want to investigate, but it's not about blaming, just get to the facts, but also appreciating it's a high stress situation where people, sometimes you see the best of people and sometimes you don't. So understanding that and preparing for that, I think, can help when it happens, to be able to pivot quickly enough in a smart way.
Yeah, thanks. Those are a lot of great insights. Look, I don't want to. We are running out of time, and we promised, or at least I promised the audience, that we were going to talk about, sort of get beyond DFS Part 500 to talk about a little bit about the present and the future of cybersecurity regulation more broadly, right? We've seen a lot of developments in the past year coming from other regulators, state and federal, as far as cybersecurity regulation goes, right? Let me start with this then. So in terms of the regulatory activity that we've seen from the SEC, the FTC, and other sources, right? What do you think are the most significant developments to date for financial services companies, right? And let me start with Luke on that one.
Thanks, Justin. Well, I think the ship has sailed, and if it hasn't completely sailed, it will be there soon in terms of who owns these risks. It is the C-suite and the board. We've long moved away from this being something the IT department should control. Even if I'm a small business, for example, to hark back to what we were talking about earlier, I can make a decision on whether I'm going to keep 6 months worth of email in inboxes or 10 years. And that changes whether a simple business email compromise, an email takeover, goes from being a bad day to being a disaster. It's just a simple business decision to decide that, to archive or set up a way to do that. So I think we've learned a lesson that from a governance standpoint, these are whole of business risks, and as such should be driven by leadership. Does that mean leadership needs to get down into picking who your, MSP is and every little vendor that you use? Of course not. But for the big pieces, they should know what are our information assets, what risk decisions are we making around them. Another thing is the two-edged sword of data, and Judy touched on this, I think, really nicely, which is, do we need to keep this? This is like going higher up a ladder with every chunk of data that we have sitting around in a data lake that we leave, especially if we leave it internet connected or network connected. When we make an acquisition, that sort of thing, and we have those legacy systems sitting off in the corner, we're sort of sitting there on risk. And so I think governance, data minimization, of course, we're all seeing earlier reporting, the new rules proposed, for investment advisors and funds by SEC for all public companies, new 8K expectations and so forth around things like ransomware, big potentially material attacks, where you are critical infrastructure. It's clear that it's not only going to be your decision, that the government, the regulators are going to push you forward because the impact on you, at least when you're critical infrastructure, could affect many others. And so you're going to be publicly accountable for the kind of decisions you make. And we should all think that way as we're future proofing.
Insights. Joe, what do you see as the most significant developments outside of DFS for financial services companies?
Sure. I would say the challenge of other regulators and regulations impacting, for example, when companies can either pay ransomware, pay extortion, pay white hat hackers, the confluence of both OFAC regulations, AML regulations, FARA regulations. There's a whole regulatory soup that financial services companies need to be aware of as they interact with people outside the organization and think about whether to pay them money, either for bringing cybersecurity vulnerabilities to their attention or for remediating cyber vulnerabilities. I think that's something to watch. Also something to watch, of course, are regulations that are going on and developing in Europe, because many regulated entities have European operations or touch Europe in ways that, even though they don't think they might be subject to the GDPR, do make them subject to the GDPR. And because they're financial institutions, they could very well be subject to regulatory enforcement actions because they are attractive targets from the perspective of regulators. No offense.
None taken. Well, that would go without comment. Judy?
I think that the challenges on the just navigating the scope of regulations are key, and what we're seeing is, already pointed out in terms of increased accountability at higher levels of the organization, increased questions as we've seen through enforcement actions with regard to third-party risk management, and to Joe's term of the regulatory soup, what I would love to see is more carrots and fewer sticks in that soup. So some rewards for companies who are providing good cybersecurity. The reward is you're not on the front page of the paper. Congratulations today, but wait till tomorrow. But really, I think if there's more perhaps that can be done to encourage cybersecurity programming, good working, for example, with law enforcement. The FTC had come out some number of years ago saying they would consider that as a means of a company doing all that it could for an effective incident response. Other things that might encourage more public-private collaboration, but with tangible benefits as opposed to just so much risk. Because right now there was a need of regulation to wake up and have this be a priority, but now there is so much, it's getting really hard. And so if we could add some carrots, I would vote for that.
And so I think at least at minimum, Joe alluded to this, right? In terms of thinking about both what the risks are and the regulatory requirements are today and what's likely coming down the horizon, right? What should companies be thinking about as far as future-proofing both their InfoSec program generally and their compliance, right? And I'll come back to Joe again.
You know what? I'll defer to my panelists on that.
All right, fair enough. Luke?
Sure. I think that the third-party and fourth-party risk issues are just the hardest area for many of our clients. It's just such a struggle, even for the largest of companies, to manage it. And I think what we've learned from some of the big attacks in the past year is that, relying on someone just because they're prolific in the sector, just because they're the go-to used by the whole financial services sector or energy sector, may actually have a different risk component to it. They may be the best or have the best product at the right price point, but they're also going to have the highest, they're going to be the most targeted. And so thinking about, what should we customize with across the board options so that we're not in the herd that's all affected at once when that vendor is struck by a nation state or sophisticated criminal group. The other thing is we're forced now to think really in depth about resilience in depth. To go to the Russia-Ukraine war, some of the threats on Western businesses that the government's been warning about are real. If a major cloud provider went down, I mean, what are the options? What are our workarounds? So you don't need to wait until you're hit. But I think gaming through these scenarios, doing walkthroughs, mini tabletops, speed rounds of different scenarios is a good exercise to say, all right, we don't have a backup to that cloud provider, but we have the data replicated over here. What do we need to move that into action? Talk through the different situations that you'd be able to continue operating as a business.
And Judy, how about you?
I think to address the evolving regulatory landscape, it's really important to think about cybersecurity as an enterprise risk problem. And we talked a little bit about this earlier, but understand that it is core to the business function and it needs senior leadership engagement to understand what are our priorities in terms of information we collect, we keep, and what we do with it, because that impacts cyber risk, as we've discussed, and the importance of having good team communications and flexibility, because there are so many different regulations. It is evolving. Who owns it within the organization? Who are your internal and external resources to make sure that you are keeping up with these compliance changes, and making sure that you have understanding within the organization of when these issues have to be escalated in terms of new regulations, new requirements, changes in policies or incidents. When does it get up to the executive team? When does it get up to the board? Is there a clear flow of communications? And again, in a positive way, not just you must have messed up if we're getting, a call from DFS, and having a proactive risk-based approach, I think, is really, really important to manage all of these different regulations as they're coming through.
All right. Well, I appreciate that. I mean, there's been a lot of tremendous insights. I'm just about done here. I'm going to wrap it up with another DFS-centric question. Despite our earlier promises, I think there are almost 100 of my colleagues watching this here at DFS. So I guess I'm curious to say, right, if we just kick it open a little bit, what would you like us, what would you like us to know? Is there something? And you've already managed to get a fair amount of that in. So if there's something else to add, that's fine too. I know we definitely don't have a shy bench today. But I thought I'd give you all one more opportunity if there's anything under the sun that you'd like myself and my colleagues to know.
So I'll kick it off if you don't mind. I mean, I think in addition to all the things that I've asked for already, I would actually say to the extent that DFS has observations about how companies get things right and how companies get things wrong, where they kind of just knock it out of the park in responding to an incident and where they fumble. I mean, again, having just kind of anonymized war stories told by someone from DFS, either in a panel setting like this or some type of roundtable, right? With the understanding, right, that it's not going to be binding on the DFS and that every case is different, every incident is different. But I think that, to the extent you've seen things that really work, where companies are able to get their heads and arms around a particular thorny problem, sharing that, I don't think takes anything away from the mission of DFS, and I think can only help other companies try and improve their situation in response to a very challenging circumstance. So I think that's just one thing. It's obviously not formal. It's just maybe just telling stories.
Fair enough. I hear you. We have put an emphasis. I think we've heard variations of that message, from the industry, and it's one of the reasons why we've put an emphasis on trying to do both more formal guidance and as much outreach as we have. So I certainly appreciate the importance of that message. So thanks for that. Luke, how about you?
Just really to say, to express appreciation for the amount of public sector engagement that you all are involved in. I mean, this is not your day job to run interactive panels and discussions and things, but I guess it is, or it should be for many, but it's greatly appreciated. I mean, we don't take this for granted or lightly, the chance to share views with you all on behalf of the sector that you regulate. So we're grateful for it. And, whereas people maybe were afraid to Judy's point, by the first version of Part 500 when it came out, but then were heartened that you made it risk-based and reacted to comments. I have no doubt that when you put out your proposed revisions for notice and comment, that you'll have a similar open mind. And, we look forward to being part of feeding into the process to make an even better regulation.
Yeah, absolutely. I mean, believe me, we are very cognizant of the fact that success of our cybersecurity regulation was based in large part, maybe even primarily, because of the great feedback that we got and the dialogue, that my predecessors who drafted it had, and the back and forth and the 2 rounds of notice and comment, and that approach, that philosophy is something we absolutely intend to continue. All right, and we'll end with Judy.
Thanks. Really great points by my fellow panelists. I'm going to adopt those. And I think I would add what you're already doing, but understanding that the concept of reasonableness is paramount, and understanding that, especially those 72 hours, but generally in cybersecurity incident response, it's messy and there are so many unknowns. And so having this kind of approach that is based on reasonableness and good communications is incredibly valuable, I think, for overall good cybersecurity. And having the awards of good companies, even if it just means a pass and not getting well, we just need to make a new action because it's time, and sharing that there are times where companies get it right and they don't have to get an enforcement action versus the times when it is necessary. So I think understanding the difficulty of it and continuing with the path of reasonableness and good communications is that, plus what Luke and Joe said. So thank you so much for putting this on today and having these kinds of conversations with us all. It's really helpful.
Yeah, and thank you all for participating. Really appreciate it. Appreciate all of your insights, right? And thanks to the audience as well for tuning in. So I think with that, we're going to wrap up the panel. We are scheduled next to jump into a short presentation by my colleague, right? An opportunity for us to say what we want to say, and then we'll get back to a second panel after that. We are scheduled for a 5-minute break. We've gone a couple of minutes over, so why don't we say that we will jump back into things 5 minutes from now, right? Which from my clock is like 11:22, 11:23, and we'll get going with the next presentation. So Luke, Joe, Judy, thank you all so much. Appreciate it.
Thanks, Justin. Thanks, everyone.
Thank you. Bye-bye.